Welcome to the Deep Dive, where we tackle complex legal topics together.
Yeah.
Today, we're zeroing in on the fascinating area of constructive trusts in English law.
Yeah, big topic.
Definitely. And this session is really designed to help you get a strong grasp of the core ideas, the key cases, the ones you absolutely need to know, and, how to actually study this effectively, especially if you've got exams coming up.
Absolutely. And just a quick note before we dive in, this material is made available to students by the University of London, and it's purely for educational purposes.
Right. So constructive trusts, what are we actually talking about here?
Well, basically, these are trusts that they don't come about because someone decided to create one, writing it all down like an express trust.
Okay.
Instead, they just spring into existence. The law imposes them in certain situations based on rules.
So the law constructs them, has the name.
Exactly. But the category itself is pretty broad, and sometimes the labels get used a bit inconsistently, which can be confusing. We'll definitely try and clear some of that up.
Good. So what's the plan?
We'll start with the really clear examples, the ones that are definitely constructive trusts.
Okay, the must-knows.
Yeah. Then we'll look at some trickier areas, where the label constructive trust is maybe debated or used a bit differently.
Right.
We absolutely have to talk about the difference between institutional and remedial constructive trusts. That's crucial.
Ah, yes. Institutional versus remedial. Heard about that.
And we'll explore why they arise. Is it because of a wrong or unjust enrichment or something else?
And cases. Lots of cases, I bet.
Oh, yes. We'll flag the really important ones for you to focus on for your studies. The goal really is to give you a clear, memorable understanding so you feel confident tackling this topic.
Perfect. Let's get started then. Clear examples first.
Okay, first up, the vendor-purchaser constructive trust. This is a classic.
Right. Selling land.
Exactly. The moment you have a specifically enforceable contract for the sale of land, equity steps in.
How so?
Well, there's this maxim.
Yeah.
Equity looks upon that as done, which ought to be done.
Okay, and what does that mean here?
It means that as soon as that contract is binding, equity treats the seller, the vendor, as holding the legal title on trust for the buyer, the purchaser.
Even before the money changes hands and the deeds are transferred.
Precisely. The trust arises then and there. Key cases you need to remember are Lysut v. Edwards, that's an old one, 1876, and a more modern affirmation in Jerome v. Kelly from 2004.
So Lysite v. Edwards and Jerome v. Kelly. Got it. And the vendor doesn't say, I declare a trust.
Nope. It's automatic operation of law. That's the hallmark of a constructive trust.
Okay, clear example number one. What's next?
Next, let's look at perfecting imperfect gifts. Sometimes equity will impose a trust to sort of finish off a gift that wasn't quite completed legally.
Right. We touched on equity not usually assisting a volunteer, but there are exceptions.
Exactly. And the key case here is Rose from 1952.
Rose. What happened there?
So Mr. Rose wanted to transfer shares to his wife. He filled out all the forms, did everything he needed to do from his end. The only thing left was for the company to register the transfer.
Okay. But he'd done his bit.
He'd done everything in his power. And the court said, well, at that point, even though the legal title hadn't passed yet, he held those shares on constructive trust for his wife.
So again, no express declaration, but the law steps in because he'd done all he could.
Precisely. Rose. Definitely one to remember for your studies.
Vendor purchaser, Rose. Got it. Any others in this clear category?
Yes, a really important one. Unauthorized profits made by fiduciaries.
Fiduciaries, like trustees, company directors, people in positions of trust.
Exactly. They have a super strict duty not to profit from their position without the fully informed consent of the person they're acting for their principal.
And if they do, say they take a secret commission or a bribe.
Right. The law says they hold that commission or that bribe on constructive trust for their principal. And crucially, this trust arises the moment they receive that dodgy profit.
Instantly.
Yeah.
Wow. What's the main case for that?
The leading authority now is FHR European Ventures, LLP v. Cedar Capital Partners, LLC. That's a Supreme Court case from 2014. Really important.
FHR European Ventures. Okay.
And it was strongly confirmed again recently in Crown Prosecution Service via Aquila Advisory Service, Ltd. in 2021. So the principle is very firm.
Even if the theory behind it was debated for a while.
Yeah, there was debate, but the outcome is clear now. Constructive trust over those profits.
Okay. FHR. Got it. Any others?
We should also mention Chase Manhattan Bank, N.A. Israel British Bank, London Ltd. back in 1981.
What was that about?
a mistaken payment. One bank accidentally paid the same amount twice to another bank.
Oops.
Yeah. The recipient bank held that mistaken second payment on constructive trust for the paying bank.
Interesting. Though I hear the reasoning in Chase Manhattan is a bit controversial.
It is.
Yeah.
We'll probably come back to that. But for now, it stands as a recognized example where a constructive trust was found, again, without any declaration.
Okay. So for exam purposes, these clear examples, Lysite, Rose, FHR, maybe Chase Manhattan, the key is understanding when they arise and why they're constructive, right? No deliberate creation.
Exactly. Know the trigger facts and the basic principle for each. Memorize those case names. That's your foundation.
Right, foundation laid. Now, what about these more disputed examples where the label is a bit shaky?
Okay, yeah. This is where things get a bit more nuanced. First up, there's this phrase you sometimes hear, liability to account as constructive trustee.
Sounds like a constructive trust.
It sounds like it, doesn't it? But it's often used when a third party gets involved in a breach of trust. Maybe they dishonestly assist the trustee, or they knowingly receive trust property.
Okay.
The term can be misleading. Lord Millett, in Dubai Aluminium Co. Ltd v. Salam back in 2002, actually suggested we should maybe stop using it in cases of personal liability.
Why is that?
Because often, the liability isn't about holding specific trust property. It's a personal liability to pay compensation, to
Right.
make good the loss.
So they're liable as if they were a trustee, but they might not actually be holding trust assets.
Exactly. Lord Millett preferred just saying they are liable to account in equity. It's a subtle but important distinction. The term constructive trustee here is more about the measure of liability, not necessarily about holding property.
Right. So when studying, be careful with that phrase. It doesn't always mean a real trust over assets.
Precisely. And this ties into cases like Williams v. Central Bank of Nigeria from 2014. This dealt with dishonest assistance and knowing recipients.
What did Williams say?
Well, Lord Sumption made this distinction between true trustees, people actually appointed or taking on the role, and those who merely account as if they were trustees.
Okay.
Now, the tricky bit is someone who knowingly receives trust property is holding specific property that came from the trust, right?
You'd think so, yeah.
But the Supreme Court in Williams held that, for the purposes of the Limitation Act 1980, these knowing recipients were not considered constructive trustees.
Oh, that seems counterintuitive.
It does. And it caused a lot of debate. Many academics argue that knowing recipients are proper constructive trustees, holding that specific property on trust, and maybe Williams should be read narrowly, just relating to limitation periods.
So the takeaway for studying this bit.
Focus on the nature of the liability. Is it about specific property, proprietary, or is it a personal obligation to pay money? And understand that the Williams case adds complexity, especially regarding knowing receipt. The debate continues.
Okay, tricky area number one. What else is disputed?
Well, think about trusts of land. Normally, Section 53(1)b of the Law of Property Act 1925 says you need written evidence to create a trust of land.
Right, formalities.
But equity won't let a statute be used as an instrument of fraud. So if someone orally declares a trust of land and relies on the statute to deny it and keep the land for themselves, equity might step in.
Oh.
The classic case is Rochefoucauld v. Bousted from 1897. The court enforced an orally declared trust to prevent fraud.
Okay, but that sounds like an express trust that just wasn't written down properly. Why call it constructive?
Good question. It was arguably expressed in its origin. But because equity enforces it despite the lack of writing, to prevent the fraud, some people classify it as constructive. The trust is sort of constructed by equity to achieve justice.
Okay, so the classification itself is debated.
Exactly. It highlights how the lines can blur.
Any others in this category?
Just briefly, we should mention secret trusts. That's a whole other topic, topic 13 of the guide, I think. There's debate there, too, about whether they're express or constructive. We won't dive deep now, but just be aware it's another area of discussion.
Okay, so for these disputed areas, liability to account, knowing receipt post-Williams, Rochefoucauld, the key is understanding the underlying issue. Is it really a trust over property, or is it something else being labeled confusingly? And know the key cases like Dubai, Aluminium, Williams, and Rochefoucauld.
That's the way to approach it. Focus on the substance of the obligation.
Right. Let's move on to the types of constructive trusts then. You mentioned institutional versus remedial.
Yes, this is a really fundamental distinction in English law.
Okay, break it down for us. Institutional first.
Institutional constructive trusts are the ones we've mostly been talking about so far. They arise automatically by operation of law as soon as a certain set of facts occurs.
So the law has preset rules. Facts match rules. Trust exists.
Exactly. The court's job is just to declare that the trust already came into being when those facts happened. Think vendor-purchaser, Lysite, Rerose, the fiduciary profits case, FHR, maybe Chase Manhattan. These are all seen as institutional. The trust exists from the event, not from the court order.
Okay, that seems fairly clear. Trigger event happens, trust exists. What about remedial constructive trusts then?
Remedial constructive trusts are different. They aren't based on pre-existing rules triggering a trust automatically. Instead, they are said to arise because a judge decides to impose one, using their discretion, to achieve a fair or just outcome in a particular case.
So it's a remedy the court chooses to grant.
That's the idea. It depends entirely on the court order for its existence. But, and this is crucial for your exams, English law is generally very resistant to the idea of remedial constructive trusts.
Really? Why? It sounds like a potentially useful tool for fairness.
The main worry is about certainty and the rule of law. If judges can just impose trusts whenever they think it's fair, where are the clear rules? It could become arbitrary, unpredictable, people wouldn't know where they stand. It gives judges too much discretion, potentially overriding established property rights based on, the length of the chancellor's foot.
Ah, the old saying. So legal certainty trumps discretionary justice here.
That's been the dominant view in English courts for a long time. There are some very strong cases rejecting the remedial constructive trust.
Which ones should we know?
You definitely need to know Pettit v. Pettit and Gissing v. Gissing. Those are older House of Lords cases. Then there's Regold Corp Exchange Ltd. from the Privy Council and Polypec International Pillick v. Nadir, number 2, in the Court of Appeal.
Polypec, wasn't there a famous quote from that?
Yes. Mummery LJ called the remedial constructive trust inconceivable in English law. Very strong language.
Wow, okay. Any more recent cases?
Sinclair Investments v. Versailles Trade Finance reaffirmed the rejection, and even more recently, in Angove's PT Ltd. Bailey in 2016, Lord Sumption explicitly said English law dislikes discretionary adjustments of property rights and generally only recognizes institutional trusts.
Okay, so the message for exams is clear. English law strongly prefers institutional trusts, arising automatically by rule, and rejects remedial trusts based on judicial discretion. And know that list of cases. Pettit, Gissing, Goldcorp, Polypec, Sinclair, Angoves.
Absolutely nailed that distinction, and the key case is rejecting the remedial concept.
Is it always that black and white, though?
Well, that's a good point. Some commentators argue the lines can blur a bit in practice. Think about cases involving unconscionability, like maybe Pennington v. Wayne, which we discussed under imperfect gifts, or those really difficult cases about shared family homes, like Stack v. Dowden and Jones v. Kernut.
Ah, the family home cases. They seem quite flexible.
They do. The courts there look very closely at the whole course of dealing and imputed intentions, which some argue feels a bit more like judicial discretion, even if it's framed within an institutional structure. But the official line remains: no remedial constructive trusts.
Okay. So understand the firm rejection, know the cases, but be aware of those slightly fuzzier areas in practice.
That's a good summary.
Right. Let's try and bring some structure to all this. You mentioned a framework by Peter Birks.
Yes, Professor Birks offered a helpful way to think about how legal rights, including trusts, arise. He suggested their responses to certain types of events.
Okay, like cause and effect. Event happens, legal right arises.
Pretty much.
Yeah.
He identified 4 main categories of events. First, manifestations of consent, that's your express trusts, people agree.
Makes sense.
Second, wrongs like torts, breaches of contract, breaches of fiduciary duty.
Okay.
Third, unjust enrichments where someone gets a benefit unfairly at another's expense.
Right.
And fourth, a sort of catch-all category. Other miscellaneous events that don't neatly fit the first 3.
So where do constructive trusts fit in Birks' map?
Mostly in categories 2, 3, and 4. They arise in response to wrongs or unjust enrichments or these other specific events.
So this isn't a type of trust itself, but a way to understand why different constructive trusts arise.
Exactly. It's an analytical tool.
Mm-hmm.
As you study different constructive trust examples, try thinking, is this responding to a wrong? an unjust enrichment? Or is it one of those other events? It can help you see the underlying logic.
Useful study tip. Okay, let's use that framework then. What about constructive trusts arising from wrongs?
Right. So usually the remedy for a wrong is money damages or equitable compensation or an account of profits.
Not usually a trust over specific property?
Not usually, but sometimes the wrong results directly in the wrongdoer acquiring specific property. Then the question is, should they hold that specific property on trust for the victim?
Okay. Are there clear examples?
Yes. One striking example is unlawful killing within a joint tenancy. You know how a joint tenancy, if one owner dies, the other automatically gets the whole property survivorship?
Yeah.
Ah,
Well, what if one joint tenant unlawfully kills the other? Legally, survivorship would operate, and the killer gets the property. But equity says, hang on, that's not right.
so equity intervenes.
Yes. In cases like Troja v. Troja, the court imposes a constructive trust. The killer holds the property on trust, usually for themselves and the victim's estate, in equal shares, effectively severing the joint tenancy after the fact. It stops them profiting from the killing.
Wow. Okay. Is that rule absolute?
Well, there's the Forfeiture Act 1982, which gives courts some discretion to modify the rule in certain circumstances, as seen in Dunbar v. Plant. But the starting point is the constructive trust.
Okay. Unlawful killing. What else?
Breach of fiduciary duty, which we keep coming back to.
Right, the FHR situation.
Exactly. If a fiduciary takes a bribe or makes a secret profit, that's a breach of their duty. And the remedy, as confirmed strongly in FHR European Ventures and CPS Vehicle Advisory, is that they hold that specific profit or bribe money on constructive trust for their principal.
So the wrong breach of duty leads directly to the acquisition of property, the bribe profit, which is then held on trust.
Precisely. So when studying wrongs, focus on what's the specific wrong? What property did the wrongdoer get as a result? And remember FHR for those fiduciary breaches.
Got it. Okay, next category in Burke's framework, unjust enrichment.
Right. Now, the basic principle here is about preventing someone being unfairly enriched at another's expense. Usually the remedy is personal. You have to pay back the value you received.
Like if I accidentally pay you £100 twice, you have to pay the extra £100 back, a personal debt.
Exactly. That's the standard response to unjust enrichment. But the big question for us is, can unjust enrichment also trigger a proprietary remedy, specifically a constructive trust over the actual money or property received?
And this is where it gets complicated.
This is where it gets very complicated and heavily debated. Let's go back to Chase Manhattan, the mistaken payment case. The original judge, Golding J., said the paying bank retained an equitable property interest in the mistakenly paid money, and that's why there was a trust.
But you said that reasoning was circular.
It is widely seen as circular, yeah. Usually you have a trust first, and then the beneficiary has an equitable property interest. Saying the interest exists beforehand to justify the trust is putting the cart before the horse.
So how else could you justify the Chase Manhattan result?
Well, Lord Brown Wilkinson, in the later case of Westdeutsche Landesbank v. Islington LBC, tried to rationalize Chase Manhattan. He suggested maybe the trust arises not from the mistake itself, but only when the recipient becomes aware of the mistake. Their conscience is affected then, you see.
So knowledge is the key.
That was his suggestion. In Chase Manhattan, the receiving bank was told about the mistake before it went bust. But even Lord Brown Wilkinson's explanation of why knowledge triggers a full trust is debated by academics. It's not entirely clear.
So still uncertainty.
Definitely. It's led to other ideas. Some academics, like Burke Hecker, suggest maybe the payer gets an equitable power to get the money back, which only becomes a trust if they assert that right. Sir Peter Millett drew analogies with rescission in contract law. It's complex stuff.
Okay, what about resulting trusts? Are they linked to unjust enrichment too?
Some argue they are. Scholars like Burks and Chambers suggested that all resulting trusts, even the automatic ones, are basically responses to the recipient's unjust enrichment.
That makes some sense.
It does, but it's also debated. And even if you accept they're about unjust enrichment, it doesn't fully explain why the law gives a proprietary trust remedy, which gives the original owner priority over the recipient's general creditors if the recipient becomes insolvent. Why not just a personal claim to repay the value? That's the big puzzle.
Yeah, the proprietary versus personal remedy distinction again.
It keeps coming back. Remember the issues with Vanderbilt v. IRC and explaining automatic resulting trusts based on retained interest? Similar theoretical difficulties pop up here.
Are there other unjust enrichment scenarios where trusts might arise?
Well, there was a minority view in Allcard v. Skinner suggesting property transferred under undue influence might be held on trust. And there's Blacklock's v. JB Developments, where land was mistakenly included in a sale.
Land again.
Yeah, the court did find a constructive trust over the extra bit of land in Blacklock's. But why treat mistaken land differently from mistaken money? The reasoning isn't always crystal clear. Plus, for registered land now, the Land Registration Act 2002 has specific rules for fixing mistakes, rectification indemnity, which might be used instead.
So studying unjust enrichment and constructive trusts sounds tough.
It is theoretically dense. For exams, focus on Chase Manhattan. Understand the basic facts, the problem with Goulding Jay's reasoning or Brown Wilkinson's knowledge-based alternative, and just be aware that it's a really debated area with links to resulting trusts and fundamental questions about why we get proprietary remedies.
Okay. Focus on Chase Manhattan and the core debate. Right. Last category from Burke's. Other events.
Yes, these are situations where constructive trusts arise that don't really seem to be about responding to a wrong or reversing unjust enrichment directly. They're more like specific, established legal responses to particular scenarios.
Like what?
We've already covered some. Specifically enforceable contracts for Land Lyside v. Edwards and Jerome v. Kelly again.
Ah, the vendor-purchaser trust.
Exactly. And the rule in Rose about perfecting imperfect gifts and related cases like Maskell v. Massel.
Right, where the donor has done everything in their power.
Yes. Also, donatio mortis causa deathbed gifts, as seen in Sen v. Hadley.
Okay.
And then there are areas possibly not on your specific syllabus right now, but they fit here conceptually. Things like mutual wills, discussed in Walters v. Allens.
Mutual wills, where two people agree to make wills in a certain way and not revoke them.
That kind of thing, yes. A trust can arise there. And potentially, the complex rules around shared ownership of the family home, from Stack v. Dowden and Jones v. Kernot, although the analysis there is intricate and often framed differently.
Also not on the syllabus, you said.
Check your specific module guide, but often covered separately. And finally, secret trusts, if they are constructive, they'd likely fit in this other events category too.
So this category is basically a collection of specific instances where the law imposes a trust for reasons other than obvious wrongdoing or unjust enrichment.
That's a good way to put it. They're established legal responses to defined factual situations.
Okay, I think I'm getting a clearer picture now. Let's try and sum up.
Go for it.
Constructive trusts are super diverse. They pop up automatically by law, not by someone's intention.
Right.
They often link back to wrongs like breach of fiduciary duty, FHR, or unjust enrichment like mistaken payments, Chase Manhattan with all its caveats. Or they arise from other specific events like land contracts, lysite, or nearly complete gifts, Rerose.
Good summary so far.
The distinction between institutional trusts, automatic, rule-based, accepted in England, and remedial trusts, discretionary, fairness-based, generally rejected in England, remember Polypec, is absolutely vital.
Crucial. Know those rejection cases.
And the term constructive trustee can be slippery. Sometimes it means actually holding property. Sometimes it just means being liable as if you were a trustee. Do lie aluminium, Williams. You have to look at the substance.
Excellent. Always ask, is it a personal or a proprietary remedy?
So for studying, it's about knowing the key trigger situations, the leading cases for each, understanding the underlying reasons, wrongs, unjust enrichment, other events, and being really clear on that institutional remedial divide and the personal proprietary distinction.
That's exactly it. If you can do that, you'll be in a very strong position.
Okay. So here's a final thought for everyone listening, something to chew on as you study more. Given all these debates, especially around unjust enrichment and the scope of fiduciary duties and the ever-present tension between certainty and fairness, how do you think constructive trusts might evolve in the future? Will the categories expand or contract? Will the courts perhaps find new ways to use them, maybe even softening that stance on remedial trusts subtly?
That's the big question, isn't it? How these powerful tools adapt to new situations. Definitely something to reflect on.
Well, thank you for joining us for this deep dive into the sometimes confusing but always fascinating world of constructive trusts.
We really hope this session has helped clarify things, giving you a solid handle on the key principles and cases, and set you up well for your ongoing studies and exams. Thanks for listening.